Is it on? Is it on? Is it on? Is it on? Change the not that one. Okay, exactly. Is it on? It's on. So, how that I do today? I can beat. Where's the sound coming from? Where's the sound from? It's touching because it's only this big. The NBA SAGAMU. The NBA SAGAMU. What's wrong? Where is the audio coming? This is all. I don't know where the noise is coming from. We are both not on. What is happening? What's happening? The audio should be off. The audio should be off, but it is on. It's going to difference. Let's just pick it up. As I said, the NBA, no, I think today and tomorrow they are having their program, the law week. So we will not be penalizing any council for not appearing in court today. These are the cases. Hello. For the cases.
Yes, ma'am. ACS more often. Me so no work on the library. I do by Jared. Mr. David Simon Bambu. Madam Francis absent, sir.
Um, Francis?
Francis absent, sir.
Representation? A. Fabian.
I'm holding the Ronson and delay for the petition.
Shadow. Where's the judgment file? Judgment in the case of Adobajade and Simon family. The petitioner, Olufunlayo Adobajade, presented the petition before this court on the 4th of March 2022 against the respondent, Dele Simon Bambu, for dissolution of the marriage solemnized on the 15th of May 2019 at the Federal Marriage Registry for Lagos State on the ground that the marriage has broken down irrevocably. Particulars of the parties. The maiden name of the petitioner, cross-respondent, is Adobajade. The petitioner. Is that Yes. Thank you. The petitioner's given date of birth is 6th of May, 1982, in Lagos State. The respondent's given date of birth is 10th of December, 1992, 1972. So. The petitioner, a real estate consultant, resides at 11 Oluwalubo Street, Ikosike to Lagos State, whilst the respondent resides at 4 Tajide Close, Agboju, Lagos State. Both parties are within the meaning of the Act of the South in Nigeria. The petitioner cross-respondent with the circumstances and facts leading to the breakdown of the marriage. And on page 10 of the petition. The facts upon which the petitioner cross-respondent seeks dissolution are that the parties have lived apart for a period of at least 2 years preceding the presentation of the petition, that the respondent cross-petitioner has deserted the petitioner for a period of at least 1 year immediately preceding the presentation of the petition. That since the marriage, the respondent has behaved in such a way that the petitioner cannot reasonably be expected to live with the respondent. The petitioner has pleaded facts leading to the dissolution of the marriage in paragraph 10 of the petition. The petitioner seeks a decree of dissolution of the marriage on the ground of desertion for 2 years, living apart also for 2 years, that the marriage has broken down irretrievably and other orders of the court. The respondent filed an answer and cross petition dated 2nd of February 2023, seeking the following orders. A decree of dissolution of the marriage between the parties on the ground that the marriage has broken down irretrievably. The respondent may have other reliefs as the court may deem fit to make in the circumstance. Evidence of the petitioner. The petitioner cross respondent, a real estate consultant, gave evidence on oath. That the respondent, Lady Simon Banwe, is her husband, resides at 11 Oluwalopon Street, Ikosike to Lagos State. Parties got married on the 15th of May 2019 at the Federal Marriage Registry for Lagos State. The marriage certificate tendered was admitted as Exhibit PW1A. The petitioner testified that the parties cohabited after the marriage at 11 Oluwalopon Street. She testified that cohabitation ceased between the parties on the 31st of December 2019. 31st of December. The petitioner, cross-respondent, testified that she did not connive or collude with the petition to bring the petition. She gave evidence that the parties have lived apart for 2 years before the presentation of the petition and urged the court to dissolve the marriage. Under cross-examination, she testified that they met through a mutual friend before they got married. He shuttles between Nigeria and Germany to carry on his business. The respondent proposed to her and promised to take her abroad, but the marriage ended because he did not fulfill his promise. Evidence of the respondent. The respondent, cross-petitioner Lady Simon Banwe, also gave evidence. He resides at 7B Amudat Street, Okwa, Lagos State. He tendered the CTC of the marriage certificate of the parties as PW1B. He testified that he works in Nigeria but travels abroad. He works in Nigeria but travels abroad for business, and he has been in business since 2006. Few months after the marriage, parties started having issues. Testified that he supports her financially and provides for her needs. Under cross-examination, he testified that he did not inform the petitioner that he is not interested in having children. Cohabitation between them ceased in 2019 when he did not return to the matrimonial home. Counsel for the parties proceeded with their oral address at the close of the case. Learned Counsel Monty Adeleye Esquire addressed the court and submitted that the petition was filed on the 4th of March 2022. Cohabitation between the parties ceased in December 2019. The petition was filed 2 years after the parties have lived apart. It relied on 15(2)D and E of the Matrimonial Causes Act. Laws of the Federation, 2004. Learned Counsel Charles Ikwe Esquire addressed the court and submitted that the cross petition was filed on the 2nd of February 2023. Cohabitation between the parties ceased in December 2019. He relied on 15(2)E and F of the Act. It is tried that matrimonial causes are sui generis and as such has its own special rules. The petitioner will seek the solution of the marriage on the ground that the marriage has broken down irretrievably, pursuant to Section 15(1) of the Act, must be able to bring himself within one or more of the facts stipulated in 15(2)(a)(8). See Ibrahim and Ibrahim citation provided in the judgment. I have reproduced in the body of the judgment Section 15(1) and 15(2)(a)(h). The onus is on the petitioner to give credible evidence to the reasonable satisfaction of the court. See the case of Oriri and Oriri citation provided, and also where the court held that it will be in the interest of the society that divorce is not granted unless the court is fully satisfied upon unassailable facts that its grant is the only remedy to the marriage. In other words, the jurisdiction of the court to dissolve a marriage is one which would not be readily applied because such jurisdiction involves the status of the parties. Accordingly, public interest demands that the marriage bond shall not be set aside without strict proof of the grounds alleged or without painstaking and strict judicial inquiry. End of quote. See also Adequacy and Adequacy citation provided where the court held that the burden is on the petitioner to give credible evidence to the reasonable satisfaction of the court, pursuant to Section 81 and 1 and 2, which has also been reproduced in the body of the judgment. The petitioner relies on 15(2)(d) of the Act, which is the fact of desertion. The petitioner testified and pleaded that the respondent left the matrimonial home on the 31st of December 2019, just 6 months after the solemnization of their union, and has since refused to return to the matrimonial home. Respondent cross petitioner also confirmed that he left the matrimonial home in 2019. The petition was filed on the 4th of March 2022. In the case of Annuity and Annuity, the Court of Appeal held, and I quote, by virtue of 15(2)(d) of the Act, a court is bound to hold that the marriage has broken down irretrievably if it is established that the respondent has deserted the petitioner for a continuous period of at least 1 year, immediately preceding the presentation of the petition. So what is desertion? Desertion is the withdrawal of support and cessation from cohabitation without the consent of the other spouse, and with the avowed intention of abandoning allegiance, fidelity, or responsibility and remaining separated in perpetuity. Put differently, desertion means abandonment or voluntary withdrawal from all marital obligations by a married person without any just cause. Thus, to establish the allegation of desertion, a petitioner must establish physical separation, avowed or manifest intention to remain separated on a permanent basis, absence of consent from the other spouse, absence of any good or just cause or justification. It is to be noted that the law gives recognition to 2 types of desertion, namely simple desertion and constructive desertion. In the former, it is the absentee spouse who has abandoned the matrimonial ship and abdicated responsibility for requisite duties, while in the latter, it is the spouse who remains aboard the matrimonial ship who is in desertion, in that the said spouse, by his or her action or conduct, expelled the other. For a regular JCA. This is over 2 years of desertion. I hold that the petitioner has sorry. It's a typographical error here. I hold that the petitioner has established the irretrievable breakdown of the marriage pursuant to 15(2)(d) of the Act. The evidence of the petitioner is that cohabitation between cohabitation between the parties ceased on the 31st of December 2019 after the respondent cross petitioner abandoned the matrimonial home. The petition was filed on the 4th of March. The evidence of the facts before the court was corroborated by the respondent. This shows that the parties have lived apart for over 2 years. The petitioner relied on 15(2)(e) of the Act. Pursuant to 15(2)(e) of the Act, parties have lived apart for 2 years and the respondent does not object to a decree being granted. In Uzochukwu and Uzochukwu, the court held that thus the parties lived apart for a continuous period of at least 2 years immediately preceding the presentation of the petition. The lower court erred in holding that there was no evidence that living apart was for a continuous period of 2 years preceding the presentation of the petition. I must add that it is immaterial who has between the parties caused them to live apart. It seems that the Section 2(e) of the Act does not permit the court to go on a fault-finding expedition. Omotunde and Omotunde relied on, and also Ibeowuchi and Ibeowuchi and Oruge and Oruge. Where 15(2)(e) is proved to, the court may dissolve without fault-finding. On the totality of the evidence before the court, I am satisfied that the petitioner has established the irretrievable breakdown of the marriage pursuant to Section 15(2)(d) and (e) of the Act. I hold that the petitioner's case is proved to the reasonable satisfaction of the court, and I make the following orders. A decree NISA is hereby granted, dissolving the marriage solemnized between the Oluwafunmilayo Okikelomo Adekwajale and Dele Simon Bam on the 15th of March 2019 at the Federal Marriage Registry for Lagos State, Nigeria. The decree NISA shall become absolute 3 months from today if there is no contrary order of this court. That is the judgment. Right. Next one.
No, number 2 on the petition. It says the court Swedish machinery and software. African meats and acquiring limited.
Malabar statutes. Yeah. Yes. Parties?
The three hundred reports. Fabian Ibuna. Another
Fabian.
Ibuna. Ibuna EGB. For the climate habit.
Summary judgment. The claimant applicant instituted the suit. By writ of summons and other accompanying processes on the 5th of October 2021, seeking the following orders: judgment in the sum of 785,610 euros and 9,878,403 naira, being the cost of service and maintenance sales, which the claimant carried out on the defendant's vehicles and equipment for and on behalf of the defendant between the 29th of February 2016 and the 31st of October 2016 in compliance with the service agreement between the claimant and the defendant. Interest accruing on the aforesaid debt at the rate of 10% per annum as permitted by Order 35 Rule 4 of the High Court of Ogun State Civil Procedure Rule 2014 from the 1st of November 2016 until judgment is delivered. Thereafter, interest at the rate of 10% per annum on the judgment sum as permitted by Order 35 Rule 4 of the High Court of Ogun State Civil Procedure Rule 2014 from the delivery of judgment until payment thereof. The claimant filed an application for summary judgment pursuant to Order 11 Rule 7 of the High Court of Ogun State Civil Procedure Rules for the following orders, which have been restated earlier. That is for 785,618 euros and 9,878,403 naira. Interest, as aforesaid, on the sum of 785,618 euros and 9,878,403 naira at the rate of 10% per annum as permitted by the rules, as earlier stated. The copy of the document. The claimant filed an affidavit of service in support deposited by Adeyo Uchioko. And exhibits AO1 and AO4 are AO1 to AO4 and written address. Exhibit AO1 is the customer support agreement or the two agreements. Exhibit AO2 is a tripartite agreement between Lafarge, Africa PLC, and Swedish Machinery and Trucks SMT Nigeria Limited, and African Pits and Quarries Limited, dated 28 February 2018. Exhibit AO3 is letter dated 28 May 2020 to the MD African Pits and Quarries Limited, Wakpo Works, Kilometer 64, Lagos Ikorodu, SAGAMU, Ogun State, signed by Bola Akérèkọ́lá Òjó Anko. Exhibit AO4 is the email from Adeoye Uchioko to Shehu Odusoya on Tuesday, June 9, 2020 at 3:05 p.m. The claimant obtained an order of the court and served the defendant by publication in the Vanguard newspaper of Friday, December 23rd, 2022. Hearing notices was also ordered and served in the Vanguard newspaper of Tuesday, January 2024 at page 26 and Vanguard newspaper of the 8th of March 2024. I hold that the defendant does not have a good defense to this suit. The defendant applicant did not appear to this suit. Summary judgment is hereby entered against the defendant as follows. The defendant is hereby ordered to pay the sum of 785,618 euros and 9.878403 naira, being respective cost of service, maintenance, and sales which the claimant carried out on the defendant's vehicles and equipment for and on behalf of the defendants between the 29th of February 2016 and 31st of October 2016 in compliance with the service agreement of the 15th of October 2014 and the tripartite agreement of the 28th of February 2018 made between the claimants and the parties. Interest on the aforesaid sum of 785,618 euros and 9.878403 million naira at the rate of 10% per annum as permitted by Order 3504 of the High Court of Ogun State Civil Procedure Rules 2014 from the 1st of November 2016 until judgment is delivered in this suit, which is today. Thereafter, interest is ordered at the rate of 10% per annum on the judgment sum as permitted by the rules from today, the date of delivery of judgment, until payment thereof to the claimant. That is the judgment.
ACS 11C 2020 states at C that
Finance presence.
Yes. Yes. Right. We can't penalize anyone today. We have been informed that they'll be having their law week today and tomorrow, and this excuse comes very hot. Please.
another 28 October. That's the
Adjourn to 2010 then for hearing.
number 4. ACS 445,000. Blue Chapel Limited. versus Ogun State government. Followed by the most of
Who is standing?
I am at the front. I think.
I didn't hear that. Register.
your name is
At the front. I think.
your destination. Adetono Adejumo. Go legal advice. For Blue Chapel.
Right. Another day said, I believe the case is at the Multidor
Yes.
for report of settlement. How far have they gone? Right. Okay. All right.
My Lord, 411, sir.
I joined to 411 then for report of settlement.
My Lord, number 5 of God. ACS 456 Ọ̀túnba Kúnṣọ́ Ògúnlúbi. Ẹ máa bọ̀ nípa sà. Alájà Kúdírà Kìsẹ́nì. Moheed Abudu. Muritala Ọlálẹ́kan Ṣítà Àdọ́. Isa Ọládìméjì Àdọ́. Honorable Bashir Ọládùnjoyè Àdọ́. Bisola Àdọ́. Fausat Ọlápẹ́jú Àdọ́. Mr. Michael Odúnúkàn. Aṣíwájú SK Ọ̀nàfọwọ́kàn. Yes, sir. I don't know about that. My Lord, first, fifth, seventh, and eighth claimants are present, sir. Why other claimants are absent? Second, dependent is present. Others absent.
Right.
Your Lordship. Salusi and for the claimant apparently. Maybe this honorable S.A. Anna appear to defendant. Especially my lord. This matter was dated for the entire country. And very see. Friends are here. Also that activity. Applied contamination and dependence in this matter has been served also. very good thing.
Who is counsel for the other side? What counsel are in court, Mr.?
Yeah.
Are you ready for PTC?
Yes, ma'am.
Okay. Then counsel for the claimant, proceed. Then counsel for the claimant. Then counsel for the claimant, Mr. Sanusi Adewa,
Yes, ma'am.
proceed, please. Your papers, proceed.
Proceed.
Your forms, what's the date of your forms?
The 4th day of March. 2022.
Filed,
Right. I'm gonna on the 4th of April.
how many issues for determination did you raise? How many witnesses do you intend to call?
Well, we have after
3 witnesses.
yes, ma'am.
How many exhibits do you intend to tender?
We have exhibit.
Did you amend at any time?
No,
Did you amend your statement of claim and read at any time?
we don't have intention now.
So what are your pleadings before the court? And you identify your pleadings.
I don't know. It's for declaration of that.
Please. Your statement, your read of someone's statement of claim, the date
Yes.
of filing. If you have any reply, the date.
They said the 24th day of October. That is the 5th of summer. 2021.
21st,
24th day of October 2021.
any amendment to that?
There's no.
Any reply?
The defendant. Yes, my lord, we find the further and better. But a reply to the human, the defendant, human reply to the statement of the defendant.
What?
We find the reply to the statement of the defendant.
Did you say further and better?
No, my lord. This is dated 7th day of October 2022.
7th October
7th day of October
2022. Those are your pleadings.
Yes, ma'am.
Okay.
Very good.
Any attempt to settle out of court?
But not the starting period, I can't have delayed. But when we approach your lordship, we have not taken any step, or any of the party have not taken any step. We see that that is not happening to be settled.
What is this about?
It's issue of title to land and all. Our claim is that the originators of the claimants gave an intention to the claimant father for the building of a bicycle park.
Right.
And that was dated, the letter is dated 4th day of March 1977. Upon the death of the the father, the nature of the famous. Of course, they were using the land for farming and even giving it to tenants until when the children felt that the teacher felt that the side time they start construction on the land. For consequence upon that the defendants said we invoke police, institution of police to arrest them, which eventually led to the issue of reporting the criminals to the
Okay, let me hear the
And
learned
the
counsel
government.
for the defendant now. Your forms, please.
So there were four with the 6th day of October 2022.
Issues for determination.
The 5 issues for examination.
Any exhibits, any witnesses to be called?
Because we have one witness before.
Any exhibits to be tendered?
No, we have evidence to finish. We have 5 exhibits.
Your pleadings?
The treaty was statement of the claim is dated 12th day of April 2022.
12th of April.
12th of April 2022.
Right. Any attempt to settle out of court?
Yes, I tried to say I don't try.
What?
As you say, if they matter, they went to the title is still of the area, and the title is really good to resolve it for them.
Yes.
Well, in the progress of that, it's not the matter came to come.
Right. Well, proceedings have been settled, the issues have been joined, no settlement reached, the case will be adjourned for trial.
That's so.
Please.
You know, 31 cents.
Case adjourned to 3110 from here. Right.
My Lord, number 6. ACA 136,012. First Elevator Company Limited versus the state government. My Lord, is at not person.
Right.
Adetono, Adejumo. For
Are they?
Tono, Adejumo.
Another date then for report of settlement.
Yes, and not 4/11, sir.
Please adjourn to 4/11 for report of settlement.
As for Law number 7 on property, sir. ACS 43,012. Incorporated trustee of Covenant Church versus your state government. My lord, the case that you want to present.
The name is not correct, sir. It's incorporated trustees of Regeneration Church.
Regeneration Church.
Have you checked the readings?
My lord, is that most present.
Can you check the readings and let me have the correct name? And let me have the file. The file is not
The file is
with
not
you.
here, yes, sir, that most just.
Incorporated trustees
Or
of
Regeneration Church.
Regeneration Church.
Okay, Regeneration Church.
and who?
And the state government.
Are you also in this one?
Yes.
As a public citizen. I just want to give you. You are quite helpful.
Right. Okay.
And not 4/11, sir.
Please adjourn to 4/11/2024.
As for physics.
Right.
My lord, number 8 on property, sir. HCJ 012/2021. Elijah Solomon Àbẹ̀ní Ọ̀rẹ́àgbà. Elijah Mujidat Sàkàsánì. Alhaji Moshood Adébáyọ̀ Sulakat. Mr. Tony Afọlábí Bẹ̀yẹ̀. Mr. Mọ̀lúkù Alánà. Princess Adébùkọ́lá Ọ̀ṣínbàjò. My lord, party staff center.
Yes.
I think it's more.
No.
MORU,
Yes.
I appear for the payment of the
Yes.
because we have an application to motion. They said the fifth day was March. Filed on the same
18th March.
March 2024.
I can't take anything today. No cancel on the other side. MBA week. Some courts will not fit today. Because of that. Unfortunately, this falls on the MBA week, and I have said we cannot penalize. They are the only council. What?
It's a fulfillment application.
Right. Did you shout? It's a motion on notice. Did you shout? I'm not here. Judgment has been delivered on the sea. First day of
First day of December 2023.
is it attached to your application?
Yes.
The judgment. So how do I know? What?
What
So I should go and start looking for it. You have requested for exhibit, you have named them. You have not attached the judgment for me to cross-check. Judgment was not delivered by this court as constituted today. And also the information on notice, the other party was not served. We don't know whether there's any appeal. Register. Proof of service of the motion in the file. Dates. Register.
No.
It's just for exhibits to be released.
That is the thing.
Okay. Now, when I say criminal cases, I don't want you to fix 10 cases for hearing.
Yes.
You understand me? Right. So for that one, you can have like other cases that are not really contentious, like this one, which is for release of exhibits.
That's it.
3010 then. Next one.
I love number 9 on the bus itself. ACS 350/2021. Chief Olusegun Ayodele, Evangelist Oyeleye Ayodele, Digital Paper Mills Nigeria Limited. I love what's absent, sir.
Right. No representation.
Yes, sir.
Eight.
Yes, sir. I don't fight the letters.
Last one.
Number 10 on the bus itself.
Okay. No.
Yes, sir. ACN 23-2014. FOAG and Trust Trading Company Limited. Mr. Kasil Olarewaju Ajibade, Gold Profile Nigeria Limited. Mr. Okepile Pilots, the Commissioner of Police of the State, the Divisional Police Officer Martin SAGAMU. My Lord, parties absent.
Date?
My Lord, 511.
Next one.
Number 11. Number 11.
What?
There was a mistake. It's from this list. It had come up before.
Not for today.
Yes, sir. My Lord, number 12 on the first. ACN 510-2023. Keep 72 Subalaba. Prince Adeshagun Otukoya. Joshua Oduniyi. Owó tí wọ́n akim. Mr. Hamilton.
What number on the list?
Number 12, sir.
8 years, 510.
510.
Right.
Mr. Hamilton Bamboki. Adekayo and Adekonde. Adekonde and Adekonde University. My Lord, passes absent.
It's
My Lord, 611, sir.
that one.
Number 13, sir. ACN 521-20. Keep 72 Subalaba. Prince Adeshagun Otukoya. Keep Adeniji Adepeju. Mrs. Shogo Adepa Akusat. Owó tí wọ́n akim. Alhaji Zumola Chokowora. Mr. Tunde Ayeola. My Lord, parties absent, sir.
Date?
611, sir. My Lord, number 14 on the first one. N23-2024. Mr. Azan Jeremiah Ayomide. Campaign Limited. Oyidamola Durodola. My Lord, parties absent, sir.
What number is it?
Number 14, sir.
Is it M?
Yes, sir. Yes, sir.
Yeah.
T.I. Umu. TIU
Or,
for the applicant. For the applicant.
Right. yes,
We have a feeling. So this is
application, date when,
yes, the motion is passing.
date,
Enter the first of the
what?
Seven,
Dated,
the first of the seven.
yes, proceed, speak up, please.
I was doing intentions. I pray my Lord.
Application on what date?
It dated the first of May.
21st, first,
First.
okay, application,
And same his father was 7. You see to move in terms of sin.
what else, date,
So,
date,
for the shopping report.
information,
I know. 24 nights.
information,
This year, what was for 2024? Abiola Olafunbo Olúwa. GT Bank PLC. Oricha Ano.
documentation,
Most of the men eat Korea. Therefore, the applicant.
yes,
The matter is that for years. The original motion that he said was the yesterday, my Lord, I received a counter affidavit from the chief of on behalf of the person grateful.
contact David from,
First, please protect.
right, Right.
Unfortunately, the council, the council, pay what we don't do that. It's not the cost now for us to proceed.
They,
Am I not, people though might not be because the key have actually filed our further and that
well, if it's not in the file, there is no point to opening it. Wait for hearing of the application. Please receive mine for hearing.
And it's 7:22. The entire Gabriel watches United Bank for Africa, First Bank of Nigeria, Union Bank, and all taxes actions.
Gabriel,
Oguntayo Gabriel watches.
can I have the file? Is this the same federal speech?
Yes.
Yes.
This was one respect. SC.
Right. Right. What is your case?
Our clients live
Right.
we are saying that we have not done anything or something.
There are no restrictions on this account. There are no laws. The applicant have access to the paid account and it uses his right as a customer. Right. Right. Please.
Yes, sir. Along 611, sir.
Please adjourn to 611 for hearing. The last one on the list is that the matrimonial case.
Yes, sir.
What is this one?
Yes, sir. Number 17 on the box, sir. ACS 2003-2021. Oladipo Adebayo. Olufade Kehinde Adebayo. My Lord, what is absent?
Please.
My Lord, 611, sir.
Next one.
Number 17, sir. ACS 334-2020. Mr. Christian Martin Okibo. Clementina Ife Okibo. My Lord, what is absent, sir?
Please.
Yes, my lord. 511, sir. Number 19, sir. ACS 09-2024. Mr. Bello Akinlede Badamosi. Mrs. Omolola Josephine Badamosi. My lord, Max is absent.
Yes. Yes. Then it is not yet before the court. They told me.
That's possible. My lord,
What is the motion for? What is the motion for? It's for suspense service. But they did not before the court. They don't put motion and say it on the day. If you come to court and you file today, it will not be in the file. There's nothing I can do about that. It's not in the file.
Well, you know, the initially found the initial mixed partner, not before the last agreements. Was the address, the initial motion.
Yes.
The Lord said it was the last one address, we should not verify the address.
Right.
And you file another motion.
Yes, but I don't have it before me. What do I do? I can't share an application that is not before me.
You should be. Not very strong.
Is it with you, Registrar?
no, sir.
What? What's the date of the motion?
It's supposed to be. 26.
This is true, you have 5 minutes. Next one.
ACS 4133. Abolaji Adelabu. Angela Awele Adelabu. My lord, Max is absent.
Documentation?
Because but I expect AWT English. Appearance is for
Right.
it's I'm gonna see how it was not so
Right.
then it's one that we are watching on it.
dispense with the respondents and application for the Supreme Court. For allowing this other.
Right.
This part of the people that
Right. Very good.
Hello. So, ladies,
So what today is we have to December
then
before we close. And then council, you are for the petitioner? Right. Please. You know the time you are using now? Let me go then. Right. Good, good.
Mrs. Osho Abiodun Bejishayo. Mr. Osho Oluwase Emmanuel. Hello, Pastor.
Please.
Hello. Hi.
Please identify the level. Right. Can you recall the number?
Yes, sir. It's here,
What number?
number 19, sir. It's here, 0924. Mr. Bello, Akiyede Badamosi. Mrs. Omolola Josephine Badamosi. My Lord, pass it back to him, sir.
Yes. I didn't hear that. Right. So you found out where she actually lives?
Yes. It. That is supported.
Right. Right. Move your application. Was that three? Two?
My Lord, I do everything.
Inside the 55 years. How many times? Fortunately, SAGAMU office is very congested. Right, is that all?
Yes, sir.
All right.
Oh,
1 minute, please. End the session.